Good afternoon, everyone. Thanks for joining us. I know that this is a hot topic for us all, mostly because it changes every 3 months or so. So hopefully we can understand what's going on right now so that we can be ready for the next unexpected change. My colleagues, as Kathy said, are Jeffrey Keel from our New York City office and Craig Olivo and Howard Miller from our Garden City office. Thank you, gentlemen, for joining me today.
It's our pleasure to be here, and particularly, Bethany, that you did all the heavy lifting. Every time I think about APPR, I feel that I've fallen through the looking glass into looking glass land, and we'll see if we can bring some clarity to it today.
All right, we'll try. So we're going to start just a brief discussion of the differences between 3012C and 3012D to refresh our memories as we've been trying to work through this over the past year. We'll talk to you about what you need to do this year, meaning 2015, 2016, what you need to do next year for 2016, 2017, and beyond, and then talk to you a little bit about negotiating those 3012D agreements for those of you, which is most of you, who haven't finished those yet. And just so you know, there's going to be a lot of things that are going to sound similar. So remember, 3012C comes before D. So the old plans, the old law is 3012C, the new law is 3012D, and we'll try to make sure that we're clear as possible through this murky water that we have. Okay. So as you know, under the old 3012C, there had been 3 components to the teacher evaluation, and those were student growth, local measures of student performance, and other measures of teacher/principal effectiveness. Under the new 3012D, we have reduced that to 2 components: student performance and teacher observation or school visits for principals. A little bit more detail. Under the student growth under 3012C, you would either have had a student growth score, a state-provided growth score for your students, for those that were in 4 through 8 ELA and math for your teachers, or you would have created student learning objectives for those teachers who did not have state-provided growth scores. Under your local measures, that was pretty much up to negotiation. Could have been based upon the state scores or other types of assessments. Could be achievement or SLO growth-based. Could have been group goals. There was a lot of flexibility in those local measures. Those 2 accounted for 40% of the APPR score. And then again, the other measures of teacher effectiveness, which is the rubric portion of 3012C, was worth 60%. Under 3012D, again, we have moved to a 2-pronged system somewhat. It's student performance now instead of state growth. There are mandatory and optional subcomponents to the student performance measure. Both of those are based upon student assessment, and both of those would either have a growth score provided by the state or would be based upon a student learning objective.
Bethany, I think our slides are running a bit behind you.
Oh, I'm sorry. Here we go. Oh, I'm sorry. I apologize for whatever my viewable presentation and my note presentation are not, there we go, are not coinciding here. All right, here we go. This is where we are. So to recap, the mandatory and optional subcomponents for 3012D, and then the observation school visit, which also has mandatory and optional components. The mandatory components of the observation being by a principal or supervisor and an independent observer, and then the optional could be peer review. Okay, under the new regulations, the transition regulations, which is going to occupy our time today, the rubric portion or observation portion of the APPR, both under 3012C and 3012D, have not changed. So we won't be going into that a lot, but if you have questions, please ask. So now we have the transition regulations, which were adopted on an emergency basis originally in December. And the commissioner has finalized those, or the Board of Regents finalized those last week. So they have been finalized. There was a minor change, some minor changes. between the regulations in December and the final regulations, which we'll discuss. But the gist of the regulations between 15-16 school year and through the 2018-2019 school year is that districts and BOCES may not calculate teacher or principal ratings using state assessments. And that's capitalized in quotes because that's a term that's defined by the regulations. And also may not use state-provided growth scores on Regents examinations. I'm calling these both prohibited scores because it's really hard to write state assessments or state-provided growth scores 1,000 times in a presentation. So when we talk about prohibited scores, we're talking about those two things. Scores based upon state assessments or state-provided growth scores on Regents examinations. And the emergency regulations or the transition regulations apply to both 3012C plans and 3012D plans. And as I said, state assessments is defined as 3 through 8 ELA and math assessments only. It does not apply to all state-created assessments or tests. So all of those other state-created tests, Regents exams, NYSA slot, the 8th grade science exams, alternative assessments, any exam that's created by the state that isn't the 3 through 8 ELA and math assessment can be used for student learning objectives and backup student learning objectives. And if you look up, it's only the growth score on Regents that can't be used. So that building score that you get on an annual basis for the secondary schools, that's what can't be used. But the Regents exams themselves are okay to use for student learning objectives. And again, there's no changes with regards to the rubric or observational components of APPR. Now, as we go through this PowerPoint in the webinar, I think one of the things to remember is that there's no transition calculation and the regulations don't apply if your APPR plan does not use a prohibited score for a teacher's evaluation. So, for example, an 8th grade science teacher under 3012D, their mandatory student performance rating would be calculated using an SLO using the state science exam as the assessment. This is not a prohibited score. So assuming that you don't have an optional subcomponent that has a prohibited score, you would just calculate that 8th grade science teacher's composite score under 3012D the same as you would for any other year. Similarly, under 3012.
Bethany, if I understand this right, you can use the 8th grade science Regents for performance, but you can't use the growth comparison on the Regents for anything. Or did I get that wrong?
Well, 8th grade isn't a Regents exam.
Okay.
It's just a test. So the Regents exams are for 9 through 12.
Got it. Thank you.
So the state doesn't provide a growth score for the 8th grade science test yet, anyway. But what it would do, also under 3012C, again, if your student learning objectives that you have for your courses that don't end in a state growth score, if they don't use a prohibited score and your local measures don't use a prohibited score, you would just calculate the way that you have been over the last several years and you wouldn't need the transition. So when we talk about how we're recalculating the scores, it's only if you need to do so because your plan requires use of a prohibited score. So this year, I guess the state was nice to us all to give us a little bit of time to try to adjust to this recent change in December. So under both 3012C and 3012D, the rule is that you would use the subcomponents or categories in your current plan that are not based upon prohibited scores. And then, and for both of those, and this is one of the changes from the regulations that were issued in December to the final regulations that were approved last week, under both a 3012C plan and a 3012D plan, you may ultimately just have the rubric score if your plan only has prohibited scores as part of those student assessment pieces. And that was different with the original regulations for 3012D plans. and the commissioner listened to districts when they talked about the burden that would be created in having to come up with backup SLOs between now, December and the end of the year. So that was a good change in those regulations. So under 3012C, if you have an available backup SLO that's not based upon a state assessment, again, it's not part of the 3 through 8 ELA or math, you should use that backup SLO for whatever component, presumably the student growth, whatever component is being precluded. Now, if we recall, backup SLOs were not required for 3012C plans or under subpart 30-2 of the regulations that apply to 3012C plans. And generally, those were created for teachers who could get a state-provided growth score, but possibly we think that there's a good chance that they won't. So if you think about a self-contained teacher that only has 8 to 12 students in her class, state only provides growth scores for when there's up to at least 16 scores. So if some of those students in those smaller classrooms sort of dropped out with their scores, they weren't tested last year, or they left before the end of the year, or they didn't take the test or opted out. If that had occurred, we would ask them to do backup SLOs, in my experience, so that they would have a score. And typically, those backup SLOs under 3012C were based upon the state assessments, and the teachers would just create SLOs based upon the state assessments. So they're not required. If you have them, you're supposed to use them. And I would ask, before you try to fit a square peg in a round hole, whether or not those backup SLOs that you might have are really for all of the teachers, or are they only just for a few that have specific circumstances. Under 3012D, the finalized transition regulations do not require the use of backup SLOs for the 15-16 school year at all. Basically, they just deleted the portion of the regulation that referenced or added a provision that is just for 2016 to 2017 and beyond, that backup SLOs are required. So for the 3012D plans, for those districts, and there's only about 100 of them in the state that have finalized those plans, you're okay without doing those backup SLOs. Again, still in 2015-2016. So in order to calculate what the score is going to be and what the rating is going to be, once you've excluded those prohibited scores, for 3012C, there's always a number calculation that we've had to follow under 3012C. What we do is we exclude the prohibited score and we scale up the rest. So basically, we just scale up whatever the point value is, and to a 100-point measure. And what this does in situations where only the rubric is going to be used, it basically creates a situation where you are going to have all effective or highly effective teachers. Because when you scale up a 55, which is a developing score on a rubric, to a 100-point scale, it becomes a 91.6, and that's a highly effective. And I'm assuming that most of us have point scales on our rubrics where even an ineffective score, if you scaled it up, would at least be an 85 on a 100-point scale because of the skewing and those values that occurred. But it's only for 1 year, fortunately. And again, if you do have a local measure score that would be applicable, then you would base it on an 80-point transition rather than the 60-point transition. For 3012D, you exclude the prohibited scores, and then you use the rating from the other subcomponents to determine what the rating would be. So for example, if you only had the teacher observation score, then that rating would be the rating for the entire evaluation. If you remember, there's a chart that we use that we'll talk about in a few minutes to determine what the rating is under 3012D. It's not based upon a point system anymore.
So Bethany, there's no scale up under 3012D?
No, because it's not really a point system. I mean, there's numbers, and we'll talk when we look at the SLOs. There are a number of values that get you to an effectiveness, but there isn't a total point value that creates a final composite rating. It's based upon the individual ratings that you get in each of the components.
So if it looks like an anomalous result, it really is. And I see you've put the Engage New York link on this page, and that will take every 25 single-space type pages of FAQs from the State Education Department, which is very interesting reading.
Yes, yes. And the most interesting part is that they do not use an example where a teacher would be rated as a developing or ineffective and scales up to an effective or highly effective. But you get to choose your examples, I guess. So now that we're moving to 2016 and 2017, we're only talking about Section 3012D plans. That's because the state is still requiring that all districts have approved 3012D plans by September 1st. You no longer have to apply for the hardship waivers between now and then, but there's still an expectation that you will have a plan approved by September 1st. Presumably, if you don't meet that deadline, the economic sanctions that are out there as far as not getting your aid from this past school year are still apply. You would still use the same calculations that we just discussed, but obviously there are those other consequences if you're unable to negotiate a new agreement. Also, starting with 2016-2017, you must have a student performance score. No longer will we be able to just go with the rubric rating for our, or observational rating for our total composite score. So those student performance scores are either going to be a mandatory student performance score if it's not based upon a prohibited score. If you're using your mandatory, able to use your mandatory student performance score, it's certainly the case that it's likely that you wouldn't have to have a transition score unless you have an optional student performance component, which is based upon a prohibited score. And again, if you have questions, I know it sounds like I'm talking in circles because all the language the state uses sounds the same, but again, you only use those transition scores and transition calculations if you have to exclude something because it's based upon a prohibited score. And if you can't use your mandatory student performance score, then you would go to your optional if that's not based upon a prohibited score. If both your mandatory and your optional scores are based upon prohibited scores, then you need a backup SLO, and you can't create backup SLOs that are based upon prohibited scores under the regulations. So ultimately, if all else fails, it will be a backup SLO. So again, you exclude, for 3012D, you exclude your prohibited scores, use your ratings from your other subcomponents. You will always have an observational or school visit rating. That will stay the same in the statute. For student performance, assuming if you think about a 4 through 8 ELA and math, where a state-provided growth score would have been the student performance mandatory score, you'll either use a valid optional student performance score or you'll use the backup SLO as mentioned. Again, if you have an optional student performance score, that's what you use. You don't need to have a backup SLO if you have the optional student performance score. It's one or the other. You don't have to have both, even though under the standard 3012D regulations, you would have to have a mandatory and optional component. Under the transition regulations, you have to have one or the other.
Bethany, we had talked earlier this morning about the difference between 3012C, which talks about observation and other considerations, and 3012D, which appears only to talk about observations and leaves out such things that you might otherwise want to mention, like the teacher never returns student homework. But I know you had some wisdom on that, and I wonder if you'd care to comment.
Sure. Essentially what the regulations provide, and this is a murky area, and I know there's a lot of concern about that, but there is some some provisions in the regulation that talks about the rubrics, that if there is a portion of the rubric that isn't observable in the classroom, that the principal or the administrator doing the observation can use the pre-conference or post-conference or any other meeting or conversation with the teacher to observe those components, and then they can be added to the observation score. So, how that's going to work in a contentious environment, I can't say, but the regulations do contemplate that you're not going to be able to see everything in a classroom setting, and that there are other components of rubrics that will need to be observed outside of the classroom. So again, we're going to, as we talk about this, we're talking about the student performance component of the overall 3012D observation. The observation school visit component or category has not changed during the transition period. And this is the chart that we talked about that I mentioned before on how we would determine the rating based upon the component scores under 3012D. And if you look at this, you take your teacher observation rating or school visit observation rating if it's a principal. You go across to where you find the student performance rating, and that determines where you will be, what the teacher's overall rating will be. So, and if you notice, the only way that you can be rated ineffective is if you get an ineffective in a developing or an ineffective in an ineffective rating. If you receive an effective rating on your teacher observation, you will get, you will always have a rating that's either effective, highly effective, or developing. And that's one of the things that I think that should be considered beneficial about the change in the statute between 3012C and 3012D, is that if your supervisor thinks you're an effective teacher, you can't be rated ineffective under the law. So now that we're looking at 3012D and the mandatory subcomponents, this slide is the one I used last July when it was when the regulations for 3012D first came out. And originally, under the standard regulations, which I'll use to refer to the regulations last July and September, you had a state-provided growth. It was either a state-provided growth score or a student learning objective. Under the transition regulations, you can no longer use the state-provided growth score. Now we use backup SLOs. You will still use student learning objectives for all of those courses and subjects that didn't have a state-provided growth score. So unless those objectives were based upon state assessments, which I know that some school districts that have already negotiated their 3012D plans, negotiated plans where there were group goals based upon the state assessments in order to try to reduce testing in their buildings, and now they have to come up with backup SLOs for those. But student learning objectives would still be part of the growth determination and the student performance determination of all of those other teachers that didn't normally receive state-provided growth scores.
Now, Bethany, what guidance do we get on what we're permitted to consider and use as adjusting factors in determining what expected growth ought to be?
Those are the same that the superintendent for the student has the control authority over the student learning objectives. Those are the same as they have been in the past. AL status, poverty, students with disability status, and prior academic history would go into the determination of what the actual growth should be. Again, under 3012D, we are able to negotiate, if we so desire, an optional subcomponent, which would cause student performance to have two pieces. Under the standard regulations, the optional subcomponent can be worth up to 50% of the student performance score, but under the transition regulations, it could be worth up to 100% if it can be validly used under those transition regulations. So again, what's stricken through here are all of the choices that we once had for the optional subcomponent that would no longer be allowed to be used as part of the transition score or the transition evaluation. We are still able to determine growth based upon a state-designed supplemental assessment using state-provided or approved growth models. But the rest of that that are still based upon state-determined levels of growth and on-state assessments can no longer be options for us in order to calculate a transition score. When we talk about negotiations and coming up with a plan, we'll still want to talk about developing a plan that's compliant with the regular 3012D. Okay, so let's talk about backup SLOs. There's a little bit of a difference between backup SLOs and what I would call standard SLOs, in the sense that your backup SLO must be based upon a state-approved assessment. It doesn't necessarily have to be a state-created assessment. You would still need to develop standard SLOs for those teachers who have state-created assessments that aren't prohibited. So again, your Regents exams, your teachers that have Regents exams, your teachers that have 8th grade science, nicest slot as a state assessment, New York State alternative assessments, those assessments are still required for student learning objectives for the mandatory component of a 3012D APPR score. The backup SLOs are only to be used for teachers whose mandatory components include a prohibited score, which is the 4 through 8 ELA or math, or who has an SLO that's based upon those assessments. And the principals or the Regents state growth score on the Regents exam. Your backup SLOs may be based upon a school-wide group team or linked result, so long as it does not use a state assessment for that reason. A suggestion by the guidelines that the commissioner developed is that you could use the 8th grade state assessment for all of your elementary teachers' student performance score. My guess is that most of us aren't going to want to do that, but that was a suggestion. And I think that some of us have assessments that we use for other reasons that are available to us that are on the approved list. Those would be able to be used to create backup SLOs. And you could also use group goals on those types of things. So if you have NWEA in your building, for example, you could create backup SLOs that are group-based for NWEA scores. And again,
Bethany, I see we have a great question from someone in the audience. And it says, since 3012C and 3012D both require the use of state assessments, how do we reconcile these regulations to the statutes? And I'm going to suggest the answer is simple. We don't. We can't. It's a leap of faith.
Mm-hmm. And I know, I've spoken with a lot of districts that are very concerned about the idea that, I think, I'm hesitating. I think that we could potentially reconcile the idea that the state doesn't provide a growth score, but I don't think that we can reconcile that we're not using the state assessments to create student learning objectives, because the statute's very clear that those are supposed to be used. But I think that those points have been brought up to the Board of Regents and to the Commissioner, and they've just kind of chosen to ignore them. Based upon the fact that there were other changes in the regulations that were finalized last week. Again, as a superintendent, you have full discretion over the student learning objectives, obviously within the parameters of the regulations. You determine the assessments. The superintendent determines what 1 year's expected growth is. They determine the growth targets. and they are, they can consider LSATs against students with disability status, poverty, and prior academic history as part of the determination of what that growth in those targets ought to be. So what we have here is, I'm sure is familiar to you. This is the chart for converting student learning objectives to ratings. So as you can see, you have a goal of the percent of the targets met. There's a scoring range in the center, and what ratings will result as those scores are reached. Interesting, as you all know, ineffective and developing. Ineffective used to be up to 2 points, and then developing used to be up to 8, I think. And effective started at 9. And so the state has significantly broadened the ineffective range, obviously, of this. But to a certain extent, we get to control what the targets are. So at least, we'll have to use those as opposed to the percentage of students meeting targets to try to ensure that our teachers are fairly evaluated. And for our backup SLOs, our SLOs, they must be state approved. And again, a state approved assessment would include those state created assessments that we've already talked about, the science, 8th grade science, Regents assessments, et cetera, other than the actual state assessments, which are the 3 through 8 ELA and math. Approval still needs to go through the RFP process to get approval for a locally developed or third-party assessment, and the link that's on here will take you to the list of currently approved assessments. And surprisingly enough, there are quite a few locally created assessments that are on that list. And just a reminder that we can't use traditional standardized tests for K2. And another reminder is that we are still restricted by the requirement that we limit our testing to 2 to 3% of the instructional time, unless it's the state assessments or state required assessments, or for other purposes. So presumably, adding an assessment, because we can no longer use the state assessments, the 3 through 8 ELA and math, as part of the APPR score, unless we're using whatever we're using as a backup SLO assessment for purposes such as, sorry, my vocabulary, the purposes that are allowed by the regulations. If it's solely just to get the SLO score, we could run afoul of that testing limitation, time limitation requirement. So one of the things that comes up is, what do we do? What do we do if, if we have a teacher that we think is pedagogically incompetent and we want to discipline them? The regulations and the emergency regulations provide that the transition ratings that are calculated must be used for employment-related purposes, including charges under 3020B. Specifically. However, and I think that that's important to note, because Section 3020A discipline is still an option for pedagogical incompetence. We don't get the benefit of all of the extra, perks under 3020B. We don't get the benefit of the expedited process under 3020B. We don't get the benefit of the assumptions of incompetence based upon the ineffective ratings under 3020B, but we can still file charges under 3020A. And if we can demonstrate that there is a incompetency issue. And Howard, you were mentioning that there were some good cases out of New York City with that?
There are, and it requires, well, first of all, it's always difficult to fire teachers for incompetence. But it can be done. It just requires some patience and some good documentation. And there are a couple of relatively recent decisions out of New York City where they terminated long-standing tenured teachers for incompetence. And in one case, it was even though the teacher's students had done well on Regents. And it ultimately came out that the students did well on the standardized tests, not because of the teacher's ability, but despite the teacher's instructional abilities. And in those cases, they really provide a roadmap how to do it. The observation reports were very clear. They were worded very professionally. They had very specific recommendations. The teachers were given the opportunity to observe other teacher mentors, so to speak. They were given one-on-one time. There was a real effort by the administration to get it right. Also, what was helpful is that there were multiple administrators working with teachers in those cases. So any argument that, well, you gave me a bad observation report because you didn't like me personally or you had some sort of discriminatory animus towards me really fell away by having multiple administrators involved. So if anyone actually wants to see those decisions, and they do provide the game plan for how to win a pedagogical hearing, you can email me and I'll be happy to send them to you.
I'd like to comment also on the appropriate distinction that Bethany's making between 3020A and 3020B. We've had some success in 3020B cases where teachers have had 2 consecutive ineffective evaluations. And the interesting approach the hearing officers are taking there is it's not a slam dunk, but it's a slam dunk if the district can show that there was a factual basis for the elements that went into the ineffective. I think what we're going to see during this transition period is that it's going to be almost impossible to get 2 consecutive ineffectives. And yes, we probably will see NYSED using H or E ratings as defenses to 3020A proceedings, but if you look back at it, what we've historically done is most teacher incompetency cases have been brought based on conduct-based incompetency. And that avenue is still open to us even if the scores look good.
Yeah, and another thing that you see in the cases is that you do have some teachers who are used to a certain way of teaching. And what was happening that way was deemed to be too teacher-directed. And they were not able to transition to eliciting more critical thinking skills. And again, in those cases, the districts did a great job of putting the teacher on notice of the problem and gave concrete ways that they could improve. Other things that come up with incompetence is sometimes you can frame the charges not so much as incompetence, but as insubordination. If you're giving specific directives as to what a teacher is supposed to do to improve, and this goes to even terminating probationary teachers as well, and they are not complying with those directives, that could be done through an insubordination charge.
Great. Thanks, guys. And also remember that you're still going to have, again, one of the good changes when the law was passed, you still are going to have full discretion to make tenure determinations at the end of a probationary period. So although you're required to consider the transition rating instead of the original composite score during this time, if you have, even if the transition rating is good, but you have other evidence that a teacher isn't doing what they're supposed to be doing, or a principal isn't doing what they're supposed to be doing, you still have the right to deny tenure. So reporting requirements. So in order to make everything easier for us, one of the not so good changes, basically we're going to have a double reporting requirement for the transition period. The state is still going to provide growth scores for 4 through 8 ELA and math and building growth scores during the transition period. We are now going to be required to calculate and report both the transition rating that excludes the prohibited scores and an advisory rating that includes them. And the regulations provide that both the advisory composite rating and the transition rating must be disclosed to parents, but we also have to give parents an explanation of what the transition rating is. So, you know, we can't hide from the scores. And an interesting thing is, you know, parents ask for the scores and they're going to be public. I can see teachers potentially and principals potentially wanting to appeal an advisory composite score because it's going to be given out to a parent or going to become public. And you know, there isn't a lot of guidance on what would happen if somebody requested to appeal their advisory composite rating, even though it has no meaning for them disciplinarily or on their record. So what do we do now? We have to, most of us have to finalize our 3012D plans. For those districts that were able to negotiate 3012D plans before the emergency regulations went into place, the state has said that those districts do not need to submit a material change request because they are going to, you know, have to revert to the backup SLOs. However, the state has created another form, which is very long, that must be submitted by March 1st, which is the supplemental form for alternate SLOs, where it's applicable. Obviously, again, for those teachers that have evaluations that aren't based upon prohibited scores, they wouldn't have backup SLOs, and you wouldn't have to worry about that, but you have to submit a plan for 2016, 2017 in the form to identify what your backup SLOs are going to be. The districts that have 3012C plans in place still, again, you must have an approved 3012D plan in place by September 1st, 2016. At least at this point. I mean, they keep moving the goalpost, but that's what we're saying, and the state is telling us right now, and waivers will not be extended past September 1st, 2016. At that time, and while you're working on your 3012D plans, you'll have to consider that you'll have to include the supplemental SLO form in order to show the state what your backup SLOs are going to be. So,
Bethany Howard, I wonder if you can clarify one thing.
Sure.
So if I'm a fourth grade teacher,
right.
And you're now not going to use state assessments or
right.
state growth scores, do you have to develop SLOs? Does the school have to, or are they just not going to be part of the rubric anymore?
Well, for this year, for 15-16, you don't.
Okay, and then the following years you would?
It depends. You wouldn't need a backup SLO if you had an optional student performance subcomponent that was usable. So, and let's, here, so this slide is just to remind everybody what we can negotiate in the 3012D plan. But to get to the question that was just asked, so when we're negotiating our 3012D plans and we're submitting them to the state, we're not submitting a transition plan to the state. What we want to negotiate is a plan that is compliant with Education Law 3012D and the standard regulations. Then when we have that plan, then we look at the transition regulations and see how those are applied to our plan. So we're not trying to negotiate a plan that complies to the emergency regulations or the transition regulations. We want to have a plan that complies with 3012D. So in your plan that you submit to the state for your 4 through 8 common branch teachers, you will click the box that says that they're going to have a state-provided growth score. But then when you actually go to implement the plan, you know that you have to have some other measure for them because the state assessment is a prohibited score. So it's possible that you could have, if you don't have an optional student performance subcomponent, then yes, you definitely would have to have a student learning objective for those teachers that's based on an approved assessment or that's based upon some group goal on an assessment that's allowed by the state. But you could have in your plan an optional student performance component, subcomponent, that is still allowable because it's based upon an approved assessment. So if you have that optional subcomponent, you don't need a student learning objective because you would use the rating derived from the optional subcomponent to get your transition score instead of a backup SLO. So again, you really should consider the application of the transition regulations when negotiating your plan, because remember, the optional student performance subcomponents are negotiated, fully negotiated with your unions. Backup SLOs are under the full control of the superintendent. So for those of us, who have already gotten to the point where the plan, 3012D plan agreement is completed or next to completed, then hopefully you were able to get something in place that gives you the flexibility that you like. But on a go-forward basis, I'm assuming that the teachers' unions recognize this fact as well, so they may try to negotiate optional subcomponents for the sole reason that if they don't, the superintendent will have full discretion over what happens with that student performance component as part of a backup SLO. So it will be, for those of you who are not finished, it'll be interesting to see how this plays out on a go-forward basis. And also I think we need to consider the implications of what's going to happen at the end of the transition period. We often know how difficult it is to get changes in agreements once they are, once they're written in stone. And, we want to try to do the best that we can to get a plan that's going to work for us both in the transition period and potentially outside of that, because, once the transition period ends and things kick in, we want something that's going to be an effective evaluation tool. Again, assuming that over the next 4 years, nothing changes. Over the last 4, it's changed every year, so it's hard. It can be hard to judge. The other thing we wanted to talk about as far as the transition, and this isn't part of the transition regulations, but it is a potential, oh, I forgot to change the name of the case, I apologize, a potential issue with the improvement plans. Now, under Education Law 3012D, it incorporated by reference the provisions that are related to TIPS and PIPs that were already in 3012C. So essentially that requirement had not changed with the enactment of 3012C. However, in the language of that, again, paraphrase of ellipses, is upon rating as developing or ineffective, the school district shall formulate and commence an improvement plan. Such improvement plan shall be developed locally through negotiations. The Commissioner's regulations that were permanently adopted in January provide that upon rating as developing or ineffective, a district shall formulate and commence an improvement plan. Such improvement plan shall be developed by the superintendent. Now, the NICET, and I apologize, I had Buffalo Teachers Federation in there because one of the president of the BTF was a party to the suit. Filed suit on February 16th of this year, challenging that regulation and saying that the commissioner acted beyond her authority by saying that the superintendent had the authority to develop improvement plans, and it was no longer developed locally through negotiations. So while that's pending, it's going to be uncertain as to what happens with improvement plans if they are imposed by a superintendent without negotiation through the union. So my colleagues can chime in, but my recommendation would be that if you have a improvement plan process that you're comfortable with and you don't have a significant need to change it, that you maintain what it is and wait for this court battle to play out before trying to impose something different than that. If you have something that's horrible, maybe a predecessor negotiated it, who knows, and you just really need to try to develop something else, just be aware that if it's imposed, if there's a possibility that later on the regulation could be overturned and that plan would not be effective anymore. And also, most likely you would get an improper practice charge from the unions for not negotiating that.
And I think in this regard, this will actually be kind of fun to watch as long as we stay carefully on the sidelines. You would have thought that NYSED would have been so pleased to get these scores out for a 4-year period that they would have used that period to regroup. But I guess in keeping with our presidential primary season, they wanted to join the circular firing squad. So what they're saying here is that the commissioner exceeded her authority, and that's going to have to get worked out. I think that from where we sit as school districts and school negotiators, it really did not ought to make a whole lot of difference. If we have 3012C plans in place, which of course we do, we've already negotiated the teacher improvement procedural provisions. In my experience, unions have been reasonably cooperative about that. They're looking for things like reasonable notice and some checkpoints in it. I've never had a union try to control the content of the tip. So if you have a plan and you're content to follow it, there will be no issues. If there's a reason why you really feel you have to rewrite that unilaterally, yes, I think Bethany is correct. That will probably lead to an improper practice charge before PERB. And I'll defer to Craig and Howard on this. I think PERB will be unlikely to defer to the commissioner if PERB concludes that the statute requires that there have been negotiations.
Mm-hmm. Well, there are some questions about the definition of traditional standardized tests. So I'll read that from the regulations for you. It means a systematic method of gathering information from objectively scored items allow the test taker to select one or more of the given options or choices as their responses. Examples include multiple choice, true, false, and matching items. Traditional standardized assessments are those that require the student, and not the examiner or assessor, to directly use a bubble answer sheet. Traditional standardized tests do not include performance assessments or assessments in which students perform real-world tasks that demonstrate application of knowledge and skills, assessments that are otherwise required to be administered by federal law, and/or assessments used for diagnostic, formative purposes, including but not limited to assessments for diagnostic screening. And so Ames Web and NWEA is my understanding. Those are not traditional standardized tests. So those are approved tests. I think that they're on the list that there's a link to in the webinar. Okay, some other questions. So I have 5 minutes, so we'll try to get to these. If a teacher has ineffective observations but effective or highly effective 3 through 8 ELA and math scores, wouldn't a teachers union defend the teacher on the basis that the teacher's evaluation is not based upon the statute? Yes, I think that that's highly possible. I think that during the transition period, there certainly is a possibility that teachers who get ineffective ratings, ineffective transition scores, will argue that they don't have the benefit of the math, of the state assessments to show that they're effective teachers. Or even going a step further, it's certainly possible that the teachers union could argue that part of the evaluation process is for students to be able to demonstrate their learning on these state assessments and get a growth score, and therefore they have lost the opportunity to prove their effectiveness because the state assessments are invalid, and therefore, you know, any evaluation during this transition period is not a valid evaluation of them.
I think NYSED will certainly make those arguments. But that's where we get back to conduct-based incompetency, I think. You may all recall there was a 3020A in which ultimately a court concluded that a teacher may have been technically competent but was a toxic colleague. And I think as to the observation stuff, if the observation includes components like not communicating with parents, not being available for extra help with students, as Howard pointed out earlier, you give instructions on that, and that case then could convert itself into an insubordination case.
Right.
Also, you know, the fact that a teacher's kids do well on assessment does not mean they could not be terminated 3028 for pedagogical incompetence. And we've had some cases that didn't go to 3028, but we wound up getting rid of the teacher. And I've heard anecdotally of other cases where you have a teacher, and let's say they're a foreign language teacher, and they really just simply don't teach. The kids do well on the regions. Well, why do the kids do well on the regions anyway? How does that happen? Well, in some areas where particularly wealthy areas, you could have every kid in the class have tutors. And we've actually seen that, where a teacher really wasn't doing any instruction at all, yet the kids passed regions because of the tutoring their parents were providing for them. So, and again, you could again see a situation where kids manage to do well on ELAs and on the math and all that, and it's more a function of the gene pool of the class than of the teacher's skills.
There's a couple of other questions. One, someone pointed out, and again, it's worth emphasizing in this context. Again, as with probationary teachers, you're supposed to consider the evaluation ratings, but those do not preclude you from denying tenure. So if a teacher gets a highly effective or ineffective on an evaluation rating during their probationary period, if you have other reasons for wanting to terminate them, then you can deny their tenure. I think that's always best to have an identified reason to do that, but your discretion is complete with regards to denying tenure, as long as it's not a constitutionally or unlawful reason for that denial. There was also a question about the student learning objectives for backup SLOs for the 15-16 school year. Again, you do not need to use backup SLOs for 15-16 under either 3012C or 3012D. If you do not have viable backup SLOs and you need to just use a rubric score, then that's allowable for 15-16 only under both 3012C and 3012D. However, if any of the components of your plan are viable, either under the student performance component or a local measure component of your plans, you can use without having state assessments be part of it, then you're supposed to use those components. And I think we have no more questions. So, and it's exactly 1 o'clock.
I think we have one.
Oh,
Craig, would you like to address the question? What happens if the district tries to negotiate in good faith, but the union doesn't agree with the 3012D plan that's presented? What are the consequences?
Yeah, I think we are up against the same issue we had with some of the original iterations of the APPR, where if we don't have a plan approved by the deadline, we risk being eligible for an increase in state aid than for the 16-17 school year. So we all need to be working as hard as we can to negotiate those plans.
And I also think that if my recollection is correct, that if the plan isn't approved by September 1st, the increase in aid that they, quote, would have gotten in 15-16 it could also be forfeit, but we'll see about what happens with that. Because technically we were all supposed to have plans in place by September 1st, 2015. And the state decided to have waivers, but. So thank you everyone for joining us. I'm sure things will be developing over time, and we'll try to keep you updated with informational memos that we send out and webinars when needed.